Okay, I say we go ahead and get started, and then folks will join as they do. We'll start with the round of introductions. I want to just start by saying thank you so much to you all for being here and for continuing to represent your clients during this time. We wanted to host this session because we know there's a lot that's changing right now in your clients, and you all might have many questions. And so we hope that this can be a place to talk through some of those common questions, some of which we don't have answers to. We are recording this session, so just by way of housekeeping, I will say you're welcome to put questions in the chat throughout, and we will have time for Q&A at the end. We're going to stop the recording before the Q&A, and our team will kind of monitor if there are case-specific questions. We won't be able to answer those. So just by way of introduction, my name is Charlotte Saul. I'm the pro bono manager at NIJC and grateful for the work that you all are doing. I'm going to hand it over to my colleague Erica to introduce herself and then pass it along, and then we'll get started.
Sure. Good afternoon, everyone. My name is Erica Askerson. I use she, her pronouns, and I'm the supervising attorney with NIJC's counter-trafficking project. And I'll pass it over to Trisha.
Thank you, Erica. Hi, everyone. My name is Trisha Tiafilo Olave, and I'm the legal project manager in our Immigrant Legal Defense Project. And I will turn it over to Teresa.
Hey, all. My name is Teresa Flores. I use she, her pronouns. I'm the supervising attorney of the U-Visa and VAWA Pro Bono Project. And thank you all so much for joining. I'm going to go ahead and share my screen. All right.
And while Teresa does that, one other thing as we get started, we are not going to be distributing this recording widely, but if you know specific folks who couldn't be here, who are working on a case, who couldn't make it today, please reach out to me and I'm happy to share the recording afterwards. But because it's all really relevant to this exact moment and we don't want it to be shared too broadly just because we know that the circumstances are changing so much. With that, I'll hand it back to the team.
All right, thank you. So yes, as Charlotte shared, this training is for our pro bonos who are currently taking cases with us. And specifically, it's about counseling your pro bono client during these uncertain times. I'm sure you all are getting a lot of questions, so we hope that this presentation or training is helpful. And just a little bit about NIJC. So we are a nonprofit organization, and we are dedicated to ensuring human rights, protections, and access to justice for all immigrants, refugees, and asylum seekers. We have offices in Chicago, Indiana, San Diego, and Washington, D.C., and we provide legal services and advocate for these populations through policy reform, impact litigation, and public education. And so since our founding about 3 decades ago, we've been unique in blending individual client advocacy along with broad-based systemic change. So for today, our objectives are, 1, to empower our pro bono partners as they're counseling their T, U, and VAWA clients on what their rights are. Additionally, we're going to address unique safety planning considerations for survivors of domestic violence, sexual assault, gender-based violence, and human trafficking. But we also wanted to just emphasize that the purpose for today's training is not to provide any general technical assistance or any to answer any questions on any specific cases that folks might have with our NIJC case. And we will not be able to provide an overview of all of the executive orders or policies just because of the time frame. So the materials in today's training are for information purposes only. It's not intended as legal advice, and we really do recommend that each attorney assesses their own client's unique circumstances in order to determine how to better advise clients. And we do want to just emphasize any information that we give today is current as of today, February 26th. We know that there's constant changes, so we do want to just emphasize that these are current as of today. And so just, again, a reminder to practitioners to just stay up to date as best as possible on any developments in the law. And lastly, NIJC is fielding an increased amount of questions from both clients and from pro bono partners. So we do ask partners to please review publicly available resources before reaching out to NIJC's to your NIJC point of contact, just because right now our capacity to respond might be a little bit limited. But we do try our best to update everything. So for today, our agenda then is we will first talk about how to identify your client's case posture and the risk of removal. We'll then give sort of a know your rights information similar to what we've been giving our clients. We'll talk about having an action plan for clients, and then we will talk about some common questions. And then at the end, we'll open it up for sort of like the Q&A. So with that, I'm going to go ahead and hand it over to Erika.
Great. Well, good afternoon, everyone. Thanks again for joining us. Before advising your client, it's important to assess their risk of removal. Each case is different, and it's up to you to advise your client based on their unique circumstances. These are some questions that can help you assess their risk of removal. Is your client already in removal proceedings? Are they subject to expedited removal? Do they have a prior removal order? Where is their TU VAWA case in the timeline of those cases? And do they have a criminal history? These are all factors that are going to impact the advice that you give your client. So first, we'll start with, is my client in removal proceedings, or is my client in immigration court? To place someone in removal proceedings, the government issues a document called a notice to appear, or NTA. This is the charging document that orders the person to appear in court and lays out the facts and charges. We've provided a sample of this document on this page. Someone in removal proceedings is already known to immigration, but as long as they've been in the US for more than 2 years, they generally have the right to have their full case heard by a judge. This means they have the right to apply for relief in court and appear before a judge before they can be ordered removed. Due to the severe backlog at the immigration courts, removal cases can take many, many years. In some cases, a client may have been issued an NTA, but ICE never filed it with the court, meaning the client received this document, but the court doesn't yet have that person on their docket. To check, we would use the automated case information system. We've provided that link. There's also an 800 number as well, and you would enter your client's A number. If your client's A number does not appear in the system, but they received an NTA, likely this means that their NTA hasn't been filed with the court. In this situation, you'd want to advise your client to monitor the automated case information, or the 800 number, so that they know when their NTA is filed and when they have a hearing. This is crucial because if a client has a hearing and does not attend, they will be ordered removed in their absence. If this client with an NTA but not filed with the court were to encounter immigration, ICE could issue a new NTA and file it with the court. And then finally, due to the backlog in immigration court, there are situations where a client is in removal but doesn't have any hearings scheduled. If a client in this situation were to encounter immigration, it could cause a hearing to be scheduled in their case. Next slide, yeah. The next factor we'll consider is when the client entered the United States. If they entered without inspection within the last 2 years, they are subject to expedited removal. Expedited removal allows ICE to deport someone without an opportunity to appear before a judge. The only exception is if they can show that they have a credible fear of return. Therefore, these individuals are more at risk if they were to encounter immigration, because they may not have an opportunity to argue their case before a judge or even consult with an attorney. Previously, the government only used expedited removal within 100 miles of the border and within 14 days of someone's arrival. The Trump administration expanded expedited removal to apply within the interior of the US and for non-citizens who have not been present for more than 2 years. If your client is someone who could be subject to expedited removal, it's important to advise them on their right to stay silent. The other category of folks who are more at risk are people with final removal orders. An individual who has an unexecuted final removal order, meaning they were ordered removed by a judge, but never physically removed from the US, can be removed by ICE without an opportunity to appear before a judge. The only way to prevent their deportation is a motion to reopen their proceedings in a stay of removal. Additionally, someone who is previously removed and subsequently re-enters without authorization is subject to reinstatement of their removal. They also can be removed without an opportunity to apply for relief. The only exception would be if they pass a reasonable fear interview, they can be placed in withholding only proceedings. People with final orders are therefore most uniquely at risk because of their lack of opportunity to pursue relief or appear before a judge. One important exception is the T visa bona fide determination process. A T visa bona fide determination automatically stays a removal order until any adverse decision on the T visa becomes final. This was added with the this process was implemented with the new T visa regulations. This is different than the U visa bona fide process, and this does not hold true for U visa bona fide determinations. A T visa applicant who is removed becomes ineligible for the T visa. And so it's really important to have this protection against the government's ability to execute a final removal order. We have continued to see bona fide determinations under the Trump administration. And so our hope is that we continue to see those bona fide determinations. Next slide. Next, consider where your client is in their T visa, U visa, or VAWA case. Do they have a bona fide determination? Or for VAWA cases, do they have a prima facie notice? Under the new EOIR docket management regulations, immigration judges have the authority, discretionary authority to terminate or administratively close cases for individuals with pending victim-based applications. So someone, and additionally, someone may seek a continuance based on the collateral relief. That said, the U visa processing times are very, very long, and unfortunately, it may be more challenging for someone with a U visa to get a continuance or get termination or administrative closure, particularly because an immigration judge may say, well, they can pursue the U visa from abroad. And so, in some respects, having the bona fide determination notice for a T or a U or the VAWA prima facie notice does provide some protection. It is not a guarantee that the person is not going to be ordered removed. And then lastly, does your client have a criminal history? We anticipate that individuals with criminal histories will be prioritized in ICE enforcement action, and someone with a criminal history may be subject to mandatory detention, meaning they would remain detained while their removal case is ongoing. The Lake and Riley Act also expanded who is subject to mandatory detention to even include some people charged with certain crimes but not yet convicted of those crimes. And so assessing your client's risk were they to encounter ICE is also going to mean assessing any criminal history and whether or not they would be subject to mandatory detention. So despite all of these things, what protections do apply? Unfortunately, ICE recently rescinded the prior victim-centered approach, which generally discouraged enforcement against individuals with pending victim-based applications. The new guidance does encourage ICE to coordinate with other law enforcement agencies to deconflict or to make sure that any ICE enforcement doesn't compromise an investigation. The prime example being removing a key witness in the prosecution of a case. However, it no longer requires ICE to affirmatively look for indicia that someone was a victim or has a pending victim-based application. However, what it does do is it directs ICE to consult with the Office of the Principal Legal Advisor before taking enforcement against an approved beneficiary of a victim-based relief or someone with a pending application for victim-based relief. The reason it directs them to consult with OPLA before taking enforcement is to ensure that they are complying with the laws, such as the 1367 VAWA confidentiality, prohibited source protections that limit ICE's ability to take enforcement action against individuals based on adverse or information from an adverse party. So a client in this situation with a pending TU or VAWA, their first defense would be to remain silent, but their second defense would be to let the immigration agent know about the pending relief, because it would then kind of trigger this next procedural step where ICE would need to consult with OPLA. Additionally, the T visa regulations direct ICE to maintain a policy of discretion towards T applicants. This is not highly specific. There is not much by way of implementing this in actual practice, but it is, it is something we can cite to encourage ICE to either decline to take enforcement or take less restrictive or less severe enforcement actions against someone with a pending T visa application.
Thanks, Erica. That's a really great segue into our next section. This section is called Know Your Rights, because this is the part of the presentation that we provide to the community, to our clients, to anybody who is wondering what protections, what rights do I have in the current enforcement arena. And the reason we're including it here is because not only are we receiving these questions from our clients, we are receiving these questions from you all, from our pro bono attorneys, because you're getting them from your clients. So we wanted to add this to our presentation so that you know what your clients' rights are and you can feel more comfortable advising them on what to do in these various scenarios. So next slide, please. ICE is Immigration and Customs Enforcement. If ICE comes to your home or your client's home, you do not have to open the door. And we want to teach our clients and their children not to open the door unless ICE is presenting a valid arrest warrant signed by a judge. I'm going to show you some samples in a few slides to help you recognize the difference between what they typically present and what they need to present in order to gain access. Okay, most of the time, ICE will not have the proper documentation that requires you to open the door. If you're not sure, if they're presenting you with paperwork and you're not sure if it is a valid arrest warrant, we recommend that you ask to review it by having them pass it through the bottom of the doorway or looking at it through a window. But once you open the door and allow them access to your home, then you are giving them permission to enter, okay? We know that we have this right to not open the door and not let them come in. However, we also know that sometimes law enforcement officers might do things even though they're not supposed to. So if they attempt to force the door open, we recommend that you make a note of as many details as possible. For example, the agent's name and ID on their badge. If there's a vehicle involved, try to get the license plate number, etc. Now, in our own homes is where we have the most protection and the most privacy. If ICE comes to our place of employment, ICE must also have a valid judicial warrant or permission from the employer to enter that private area. So if the employer knows these rights and does not grant ICE permission to enter the place of employment, then that is the ideal scenario. Once the employer allows ICE to come in, then it's as if they are granting them permission to search. But if they don't, then similarly, ICE would need to have a valid judicial warrant in that scenario. If ICE comes to your place of employment and the employer lets them in, you do not have to answer any questions, and your employer cannot force you to answer any of ICE questions. We all have the right to remain silent. Okay, we're going to get into that in a little bit more detail in a moment. But as Erica mentioned, that is our first defense, the right to remain silent. We also strongly recommend that our clients do not carry any false documents on their person. So many of my clients, it is very common that they have used false documents to obtain employment, but we strongly recommend they don't use those documents on a day-to-day basis. They don't carry those documents with them to work, okay? On the contrary, we recommend that people do carry a valid photo ID if they have one, preferably a state ID or a state driver's license. Here in Illinois, people with any immigration status can obtain a driver's license or a state ID. That would be preferable because those documents do not indicate whether you are here with immigration status or not, right? A passport from another country might indicate that you are here without legal status. So we don't necessarily recommend that people carry their passport. If they don't have a separate valid photo ID, then yes, they should carry their passport. If they want to carry their passport, we would recommend they carry it in a different place than their driver's license or state ID, so that in the event ICE requests documents, they could just show the valid state ID or driver's license. If ICE encounters you in a public place, then they do not need a judicial warrant. And if you are stopped on the street, first, ask if you are under arrest, if you are free to leave, and if the officer indicates that you may leave, do so in a calm manner, right? This can happen to any one of us in a public place. It's happening to US citizens. So we recommend really that everybody follow these guidelines because it puts the burden on ICE to do their job, to get a judicial warrant if they're looking for a particular individual. Next slide. Thank you. So if ICE comes, first and foremost, do not lie. Do not give them any reason to hold that against you in the future, right? Do not claim to be a US citizen if you are not. I recommend that you say, I want to remain silent. I want to exercise my right to remain silent. Don't give any explanations, excuses, or definitely don't give any made up stories, okay? We also recommend that you do not sign any documents or speak with anyone about your immigration status except for your attorney. So hypothetically, if ICE encounters me, first and foremost, I'm going to exercise my right to remain silent. If they detain me, then I recommend not sharing anything about my immigration status until I speak to an attorney, and then only speak about your immigration status with that attorney. As Erica mentioned, though, clients with pending VAWA, U, and T applications are a bit unique, and having a humanitarian-based application pending, such as a VAWA, U, or T application, could be helpful and could be positive discretionary evidence to help them get released from detention. So I really say that it's a case-by-case analysis between you and your client on how to prepare for that. And you can always check in with us. But for clients who already have a valid bona fide determination or prima facie notice and possibly a work permit, those documents could potentially be helpful. Next slide. We recommend clients practice these responses to ICE, especially if English is not your first language. Having these phrases right up here, you know, ready to go can help in that moment of panic, right? So I have the right to remain silent, just practicing that. I want to speak to my lawyer. I want to make a phone call. I want to see a judge. So if someone is afraid to go back to their home country, they need to say something. And that would be why you might say, I want to see a judge, right? Because ICE no longer is required to ask, are you afraid to return to your home country? But if somebody affirmatively states that they are afraid to go to their home country, then they should be granted a credible fear interview. Next slide. So what do I say to ICE? If this is once you are already detained and you are or being processed to go to a detention center, we recommend only giving your name and date of birth. You are not required to share this information, but doing so could help family and friends locate the detained individual in the ICE online locator system, okay? You do not have to give any more information or answer any further questions, but giving your name and date of birth can help family and friends locate you in the system. We then recommend that once somebody is detained, they memorize their A number. That is a 9-digit number that begins with the letter A, and it's usually found on your bracelet when you're processed in a detention facility. If someone already has an A number based on a pending application or a prior immigration case, then it's helpful if they know that A number, because then again, they can pass that along to family and friends, and then that number can be connected to their case once they're detained. And then of course, ask to speak with an attorney. It's important that you know, here in the US, immigrant detainees are not granted an attorney. So everybody has a right to an attorney at their own cost, but they're not granted a public defender as we are in our criminal immigration system. And so it is typically the individual's responsibility to find an attorney to represent them in their immigration case, okay? Next slide. This is an example of an ICE administrative arrest warrant. This is the form that they will typically present to someone to show that they have the authority to arrest them. But this is not a judicial warrant, and it is not signed by a judge. Next slide. This is an example of an immigration detainer. This is what allows them to detain someone. But again, this is not a judicial warrant, and it is not signed by a judge. Next slide. This is an example of a judicial warrant. So you'll see up on the top, it does authorize ICE agents to enter your home. It is issued by a court. It's labeled search and seizure warrant. And then it specifies who and their address, who they have the authority to arrest. And then it is signed by a judge, and the date on the warrant should not exceed 14 days. So this is the document that actually matters, and it's quite rare that we see ICE present a judicial warrant in order to try to enter a property and arrest someone. I saw that there were a bunch of questions in the chat while I was speaking, and I'm not sure if folks have been able to respond or if I should address any of those right now.
I think we got responses to all of them.
Excellent. Okay, then I'm going to go ahead and turn it over to Teresa for the next section.
Thank you. So with all of this, what we've been recommending to our clients in the community is really the importance of having an action plan then. So a common question that we get and something that we recommend including in an action plan is, what documents should someone be carrying with them? So we would recommend having a valid photo identification in the United States. So this could be a state driver's license or the Chicago city key. But really, we would also advise not to carry any identity documents from the client's home country, unless it's their only valid form of identification. But so, for example, if someone has a driver's license, like a state of Illinois driver's license, we would recommend carrying that versus like their passport from Mexico or Honduras. That would be recommended. If someone is a permanent resident, they should have their permanent resident card with them, or if they have a work permit card, then that would be recommended to carry. And that would be separate from their ID, but again, only present it if necessary. So there's no, like, as we previously mentioned on your rights, you don't have to just present it, but carry it with you. And then again, just emphasizing, we really cannot emphasize enough, do not carry any false documents, because that could sort of lead to additional problems or challenges with the case. We've also received questions of whether if someone has a pending TU or VAWA application, if they should carry proof of that application with them. And our position is that we should carry a copy of the receipt notice or the deferred action notice, the bona fide determination or prima facie notice. They should carry that, and that would be separate from their ID. So always still have that ID, but also carry those specific documents if they have them. But if they encounter immigration, the first instinct still should not be just to present those documents. It really should be to exercise their right to remain silent. Now, if they're arrested or detained, then we would advise to tell the officer about this pending application and present the notices that they have only if it's necessary. So with an action plan, really the main point of this is to prepare it in case someone is arrested or detained by immigration. And so the action plan would include having an emergency contact, identifying this individual who's going to be your emergency contact, making sure that they're memorizing their A number and giving it to their emergency contact. The reason being, if someone is detained by ICE, they might not immediately be able to call their emergency contact or be able to immediately call their attorney. But with the A number, you would be able to see in the system if they're being held by ICE and where. Additionally, if our clients have children, we would recommend that they tell the children's school about who their emergency contact is, to let them know that this person has authorization to pick up their children. And then additionally, making sure that all of their documents are in a safe place. This would be the passport, identity documents, proof of physical presence in the United States for the last 2 years, and financial information. This is just important. If someone were to be picked up like in a public space, they likely won't have these documents, but it would be good for someone to know where the documents are so that they'd be able to access them. Now, with the action plan, we've also received some questions about if someone needs a power of attorney. So the power of attorney, it's this document that gives an authorized person access to bank accounts and allows them to make any financial decisions on their behalf. But this can be dangerous. And so we would sort of caution clients against this. Many banks allow for folks that are outside of the United States to still have access. And in some cases, an individual can still complete a power of attorney from outside the United States. So really, there's no immediate need to get a power of attorney before anyone is in removal proceedings. Just again, this isn't something that they should urgently need to do. The next question that we've received is about legal guardianship or custody for children. And so clients are able to give guardianship to a designated person to make decisions about the care of a child. But again, this is something that can be dangerous just because it could be seen like waiving your rights. So it's important to have a plan in place. But in terms of just making sure that there's someone designated that our clients trust to take care of their children if something were to happen, if they were detained or deported. And it's also important to be clear that this person knows, or that their wishes of what will happen with the children is documented somewhere, and just clear to whoever is this person that's gonna be the designated individual. And it is possible to have a guardianship custody order, that's only enforced, if the parents are deported. A guardianship can also be entered after one or both parents are outside of the United States. So there's no need to really do this immediately either. And I can say when I previously worked with detained folks in Arizona that were in ICE custody, and we did sometimes have clients that were parents. So, and mainly the main important thing was just that there was someone that was identified as who is going to take care of the children and what the wishes are of the parent. But having this guardianship identified was not necessary at the moment. So it's just something that we would advise our clients, but obviously that they're free to make their own decisions, but just so that they know. So previously we had mentioned when you're making the assessment of a case, the importance of checking if someone is in removal proceedings or have an active case. And so this is just one way to, or how you can check if someone has a case with the immigration court. There is a 1-800 number that they can call, and the automated system is in English or in Spanish. They would enter their A number, so that 9-digit number. They would have to follow along with the prompts, and then it would verify the spelling of the client's name, and then prompt them to either specify if they want to know when the next hearing is, or what the address of the court is, or the name of the judge. So that's one way to check. Another way to check is also online. So here we have the link of how someone can access this online portal. And similarly, they just need their A number, and then it should show what is happening with the hearing, like if there is one scheduled, when the next one is, and any information like that. Or if there was previously a decision made on this case, it would show too. All right, comment, questions? I'll turn that over, I think, Erika.
Great. Yeah, so up next, we want to review some common questions that we're getting from clients. We know that it is really challenging to advise clients in this climate. That is why we're having this training. There's a lot of information out there, both correct and incorrect information, and there is a lot that we cannot control and we cannot predict. It's really important to not make any guarantees about a client's case. Clients often ask us how likely we think their case is to be approved, and that is just not a question that we can answer. We need to remember that processing times can and likely will change. There is a very extensive backlog of U visa cases. There is also a growing backlog of T visa cases. I also anticipate what we saw under the first Trump administration was extra scrutiny on some of the T visa elements, and that did lead to increased processing times. And so we want to make sure that we're appropriately managing our clients' expectations by not making guarantees over things that we cannot control. It's also important to stick with the facts and be honest about what you know and don't know. Part of the administration's strategy is to create fear and panic. There's also a lot of misinformation, particularly on social media. Accurate and reliable information is crucial to our clients, especially survivors of human trafficking, domestic violence, and other forms of gender-based violence. Many of our clients, abusers or traffickers, have weaponized the immigration or legal systems against their clients and made these threats of deportation. And so, you know, especially the clients that we're working with, it is vital that they have access to correct information. But we want our clients to still be able to live their lives. We want them to send their kids to school and get medical care when they need it. And so while informing our clients of their rights, we also need to balance avoiding undue fear, panic, and speculation. And so some of the common questions that we get, back one slide. Yeah, so the first one there, perfect. Does my pending TU VAWA protect me from removal? It depends, which is, I feel like, the common law school answer. It depends on a lot of the circumstances that we discussed before. If your client entered within the last 2 years, or entered without inspection over the last 2 years, or if they have a prior removal order, ICE can execute or reinstate a prior removal or issue an expedited removal order. Other than that, most people have the right to appear before an immigration judge before they can be ordered removed. And when they appear before the immigration judge, they can argue their TU or VAWA case as a defense to being removed. But the pending application does not prevent ICE from detaining someone or placing them in removal proceedings. Again, under Trump 1, we had success getting continuances for pending T visas. The new EOIR docket management regulations also give us more grounds for termination or administrative closure for T and U and VAWA cases. But we did see pushback on long continuances for U visa cases, given the processing times and because the U visa can be pursued while someone is abroad. Again, a T visa bona fide determination automatically stays in order of removal, and a T visa applicant who is removed becomes ineligible for a T visa, and so that protection is especially crucial. Another common question we get, again, often related to the abuse that our clients have experienced, is can my abuser or can my trafficker report me to immigration? The VAWA confidentiality protections at 8 U.S.C. 1367, which also apply to T and U visa cases, prevent ICE from relying solely on information obtained by an adverse party in a TU or VAWA case. It's not to say that an abuser can't try to report someone to immigration, but ICE is prevented on solely relying on that information when making an adverse determination of admissibility or deportability.
Another common question that we've received is, well, what happens to my application if I'm denied? So if my TU or VAWA application is denied, will I be placed in removal proceedings? So we really go off of what happened in the first Trump administration. And I think it was around 2018, there was a memo regarding notices to appear that directed USCIS that if someone, if a request is denied and the non-citizen is unlawfully present in the United States, then that they would be issued a notice to appear. So it is a possibility, and we do let clients know about that. One thing to note, though, in the regulations, and the specific code is 8 CFR 214.204 B3, it does state that USCIS will generally not refer any T visa applicants to proceedings if their application is denied, but we are still yet to see how this is implemented. Then another question that we received, and this really goes to a lot of the misinformation that has gone on social media, is whether this administration is going to take away TU or VAWA application or protections. And so it's just really important, and something that we've really been emphasizing with our clients is that these, the T, the U, the VAWA, Congress wrote these protections into law, and only Congress can take them away. So oftentimes we hear from our clients, like, I saw on TikTok that the president said he's going to get rid of the U visa program. So it's not that simple to do that. It is, again, written into law by Congress. And so that's just something that we've reminded our clients.
So if your family member or your client is detained, they're wondering, what happens if I'm detained? Who can I call? So if they call you first, then please reach out to your point of contact at NIJC, depending on if it's a VAWA, T, or U case. But most likely, they're going to reach out to their family member, and then their family member is going to reach out to you. So again, if they do that, please reach out to your point of contact. NIJC also has a detention project, and the detained immigrants can call NIJC's detention project. That information is on our website. There's a hotline. It's 312-583-9721. And then the detention project also does intakes on Tuesdays with family members. And that number is 773-672-6599. And I can put this link in the chat. But essentially, yeah, I will put the phone numbers in the chat. When the client or family member reaches out to you, connect with us so that we can try to provide the best advice possible. Again, it's going to be case specific. Can someone travel within the United States? So Illinois does have laws that prevent local law enforcement from cooperating with ICE. We here in Chicago also have laws as a sanctuary city preventing local law enforcement from cooperating with ICE. That is not the case throughout the country. Other jurisdictions may not have the same protections, and local law enforcement may be likely to refer individuals to ICE, even for something as small as a traffic stop. So we strongly recommend that clients consider where they are wanting to travel, how they will get there, and what kind of identification they have. Because the reality is, if they are going anywhere near a border stop or a border checkpoint, then they are at risk of encountering CBP, Customs and Border Patrol. So that could be a border point on the Canada or Mexico border, or it could be any international airport. CBP also cooperates with ICE. Under this new administration, many federal law enforcement agencies are cooperating with ICE. So any interaction with a federal agency could put the client at risk. Traveling on Amtrak or Greyhound or in a car can also be risky. So we really encourage clients to think twice before traveling. Any air travel that could be potentially diverted to another country, right? So even travel to Puerto Rico or Hawaii is risky because there is always the chance that it could be diverted to another country. And I've also heard through national listservs that any travel to Puerto Rico goes through customs. So that is potentially risky. For clients that have valid status, like a permanent resident status or a non-immigrant status, like a T or U visa, it may or may not be as risky, but those are case-by-case determinations. So I would encourage you to first talk with the client, and then reach out to your point of contact at NIJC. I do want to make one more comment before we move on to the next section, that separately from these questions, just yesterday, USCIS announced a registration process, okay? If you hear about this registration process, just know we are aware of this, but there is currently no implementation date. And so we recommend waiting until there is more information before deciding how to proceed for your clients. When I refer to a registration process, I mean that the government is going to try to require individuals to register with the government based on whether they have previously registered with the government. And so we are waiting for more information before advising clients and pro bono attorneys on how to proceed. We recommend not creating an online account for this registration process yet until we know more information.
Great.
And then, yeah, go ahead, Erica.
Great. Before we open it up for questions and answers, we do want to share with you some additional resources. These are resources that we have found to be really, really helpful. And these are, vetted and, put out by reputable sources. This will be included. We will share the slides, so you should have access to these links. And I will add, there was just the other day, the ILRC released a toolkit related to expedited removal. I'll throw that in the chat as well. That one I think is also a really great tool if your client may be subject to expedited removal. So again, if they entered without inspection within the last 2 years. Next slide. And actually one more slide. I hope is the yes. Any questions, please do reach out to your NIJC point of contact. I am the point of contact for TVISA cases. Teresa